So my recent book, Inventing American Exceptionalism, The Origins of American Adversarial Legal Culture, 1800 to 1877, explores a question that we've not really thought about seriously from a historical perspective, which is why it is that we have the very distinctively lawyer-driven adversarial system that we have in the United States. I go back to the 19th century and I recover a forgotten set of procedural practices which look a lot more like the judge-controlled quasi-inquisitorial methods we associate with Europe. And then I show how by the time of the end of the Civil War and Reconstruction, we had largely turned away from those more judge-controlled procedures to a more lawyer-driven system. I explore a number of reasons why we made the shift to a lawyer-driven system. Some of the reasons had to do with really small, little changes that were perceived at the time to be just tweaks in the procedural system. And some of the reasons for the turn to a lawyer-driven adversarial system had to do with the ways that debates over procedure in the 19th century ended up becoming tied up with a set of broader debates really about the core of American identity in the 19th century. So advocacy of adversarialism became linked with demands for a largely unregulated market and efforts on the part of some to preserve white supremacy in the face of the challenges posed by Reconstruction. European systems have historically been much more judge-controlled. In law schools, we tend to focus on the positive aspects of the lawyer-driven approach that we have in the United States, and there are many. But I was also well aware of the downsides of the system that we have. Among the big ones, an enormously high proportion, not only of poor people in this country, but middle-income people in this country, are unable to bring a lawsuit, in no small part because they cannot afford a lawyer. So credible estimates suggest anywhere from 60 to 80% of the civil legal needs of poorer people in this country simply are unmet, which means in practice that people just have to live with the bad stuff, the injuries, the unfairnesses that happen to them. In European systems, which have judges do much more of the procedural heavy lifting, lawyers matter less. And what that means in practice is that how you do in court turns much less on whether you're rich enough to hire a fancy lawyer.